All rise. Court of Appeal headed for the 5th District of the State of Florida is now in session. The Honorable James A. Edwards, Chief Judge, presiding. All persons having business before this court draw near, give attention and you will be heard. May God save the United States of America, the State of Florida, and His honorable court. Please be seated.
In that order. Bringing up the rear. Right to
All
our
right.
center.
Well, welcome to a session of oral arguments before the 5th DCA. I've already been introduced. To my right is Judge Brian Lambert. To my left is Judge Harvey J. Each side will have 20 minutes. The appellant will have 5 minutes for rebuttal, and unless you want something different, tell me, and we can set that all up. If you have noisemakers, please put them on silent. The system here is really quite easy. You can see how many minutes you have total on the clock. When you're green, you're good. When you're yellow as the appellant, you're into your rebuttal time. When it's red for each side, please stop. And if you need a little reminder as things go along, I'd be happy to do that. We have one case this morning on the docket, and that's case 23-1784, the Walsh Group versus Zion Jacksonville. So, counsel, when you're ready to proceed.
Good morning, and may it please the court. Alyssa Corey of Schutz & Bowen on behalf of appellant, and we would like to reserve 3 minutes for rebuttal. Thank you. The trial court incorrectly determined that only 2 of Zion's 6 claims against Archer Western were subject to arbitration pursuant to the parties' purchase order agreement. That decision should be reversed for 2 reasons. First, even applying the significant relationship test typically applied for broad provisions, a sufficient contractual nexus exists to warrant arbitration of all claims. And second, the plain language of the agreement's arbitration provision compels arbitration of all of Zion's claims. Now, the parties agree that the prerequisite to arbitration at issue is whether an arbitrable issue exists under the agreement as to the remaining 4 claims against Archer Western. And it's important to note that this is not about who did what wrong, it's about who decides. And so when we're looking at the contractual nexus test outlined in CFERT, even in determining the scope of the arbitration provision through the CFERT lens of broad or narrow clauses, a significant relationships exist between the remaining 4 claims in the purchase order agreement.
Ms. Corey, in our evaluation of the significant relationship test, it would be your client's position that we focus on the language of the complaint and the agreement?
Yes, because
Anything else?
well, as explained by the Florida Supreme Court in Jackson, the claims have a contractual nexus when they're inextricably intertwined with both the circumstances that surround the transaction
Thank you, and I understand the law, and you did a nice job of elucidating that. My question is a little bit more basic. In our analysis point, I understand the law is the law, but we look at the complaint as pleaded, and we look at the contract as incorporated by reference. Anything else?
No, we shouldn't be looking at anything else.
Okay, those are that's our template for applying Seaford and Jackson and the progeny, correct?
Yes.
And so it would be your position that by virtue of this incorporation by reference of the complaint through the counts in question, that in and of itself would create this contractual nexus between the agreement and the claims advanced.
That would certainly be one thing that this court could look at, but I think what's even more specific outside of the incorporation by reference of the complaint is the allegations itself on the 4 remaining claims at issue.
And so what do we know? We know the agreement is incorporated into these counts, correct?
Yes.
And these individual counts that you're speaking of, the 4, that there was a determination by the trial judge that there was not an arbitrable issue, the trial court said there was no nexus between the agreement and those claims, correct?
Yes.
And so your position, as I understand it, I don't want to speak for these my esteemed colleagues, but as I understand it, is that the way these are pleaded, that you need the agreement in order to understand whether in fact there's a cause of action or not.
Yes, and that's when, if we're looking at the purchase order agreement, it's important to note the relationship between these parties, and specifically Archer Western's presence at the Zion property was required for performance of the agreement. And the contract is about how Archer Western treats Zion's property. So no matter, how, obviously the complaint itself incorporates by reference the allegations in the complaint, where there's an entire section discussing the purchase order at app 36 to 37. And then if we're looking specifically at paragraph 134 of the complaint at app 37, the allegation is that Archer Western exceeded the authorization granted in the purchase order contract to use the Zion property in a completely different manner and for a completely different purpose than what was explicitly spelled out in the purchase order contract. And so when we're defining the conduct of these parties, we obviously have to, in order to define what is unauthorized, as identified through the allegations of the complaint, we would have to look through the terms of the purchase order to define what was authorized.
And what you just referenced, and I've got the complaint up, it's under a section appropriateness of Zion's claims for relief, and it looks like in 127, 128, 129, 130, 134, 135, there are references to the agreement and how, in essence, this was outside the agreement.
Yes.
And so and again, I want to make sure I understand, what you're saying is in order to understand if it's outside the agreement, meaning if there was a trespass, if there was littering, if there was gross negligence, you have to understand what the agreement says.
Exactly.
And again, as pleaded and incorporated by reference in these claims.
Yes. And the complaint, as you've pointed out, in the counts itself incorporates by reference all the other allegations, not only the purchase order agreement itself, but all the allegations in the complaint under each count specifically incorporate at app 39, 45, 51, and 52, the other allegations in the complaint.
And again, to make sure I understand, it looks like every count incorporated by reference 143 paragraphs.
Yes.
Meaning the entire predicate has been incorporated by reference into each individual count.
Yes.
And why is that significant, Ms. Corey?
It's significant because although CFER explained that not every dispute that arises between contracting parties should be subject to arbitration, this is not a case where it was a mere coincidence that the parties in dispute have a contractual relationship. Here, the contractual requirements, as pled in the complaint of Archer Western pursuant to the agreement, are material to the allegations underlying the claims at issue. And they're related to the conduct that is unique to the parties' relationship as defined in the agreement. And so therefore, reference to and construction of the agreement is necessary to resolve the claims at issue, and therefore we get into that satisfaction of the contractual nexus between the claims and the complaint at issue.
I believe I understand, and maybe these other judges may have some questions about the significant relationship test, but I would like to ask you about the plain language argument you make. As I understand our task, it is to read this agreement reasonably, not strictly, not leniently, I mean, you use the words of Scalia, but to read it reasonably. And reasonableness to me strikes me as reading it in context. And if we read it in context, wouldn't we have to discern that any controversy or claim would apply to the agreement it's a part of?
Yes. And that's, the plain language of the arbitration provision should be what defines the party's intent as it relates to the scope of the arbitration.
So I just want to make sure I understand your answer. So if these two entities had some sort of controversy outside the agreement somewhere else, in some other state across this country, it would not be your position that this arbitration clause would demand arbitration.
Correct. And of course, that's not what we have here.
I fully understand. That's just a hypothetical. So you would agree that the agreement itself provides the predicate foundation for understanding any controversy or claim under the arbitration clause?
Yes, and obviously the plain language doesn't include the limiting language that is typically applied for broad provisions. It is limited to, it doesn't include that limiting language of arising out of or relating to the agreement. So that analysis of the contractual nexus, why it's obviously something we disagree with, but would still satisfy, should not be employed when the provision is plain and unambiguous as to its scope.
Would you also agree that if we were to find a significant relationship, a nexus, we don't even need to go through the plain language analysis?
Correct. And that's, because, we, a contractual nexus exists here because of the circumstances in which the resolution of the disputed issue requires reference to our construction of that portion of the contract. And so ultimately, when we're looking at evaluating whether an arbitrable issue exists, any doubts as to whether a claim falls within the scope of the agreement should be resolved in favor of arbitration. And it's not just the purchase order being attached to the complaint or the general allegations. When we're looking at the 4 remaining counts that were not compelled to arbitration, there are allegations underlying those claims that would also require reference to the purchase order for resolution of that complaint. Specifically looking at the violation of Florida's litter law, there's the allegation that Zion never granted Archer Western permission to dump or dispose of the litter and materials on its property. And then when we're looking at App 93, Article 7.9 of the agreement imposes an obligation on Archer Western that Archer Western agrees to be bound and comply with all federal, state, and local laws, ordinances, and regulations applicable to Archer Western's entry of the property of Zion and removal of that fill material. And so Archer Western was required by this agreement to visit the Zion property during the excavation process, and that included preparation of the area afterwards and construction of haul roads. So the allegations that are underlying these 4 claims required that reference to what was permitted conduct. This is private property. Archer Western was permitted to be on this property. And so it wasn't, defining that conduct is going to require reference to the contract in these allegations. So looking at trespass in count 7, there is the allegation specifically in that count that the right and authority of Archer Western and its employees, representative agents, or others within its control to enter the Zion property was limited to excavating fill material to elevation plus 10 feet at App 45. But obviously the agreement itself allows access to the property, and so any trespass finding would require determining the permissible scope of Archer Western's access to the property. And then the agreement also provides that these parties are going to mutually agree to a final elevation based on the conditions, and then Archer Western is going to grade each site to an agreed about elevation before proceeding on to the next phase. And so these fact finders are going to have to evaluate the elevations that Archer Western excavated down to. The same is true for the organized fraud claim, with the allegation that Zion did not receive payment from Archer Western, whereas the agreement memorializes the parties' bargained for exchange and the related obligations as to the scope and performance of that work and the prices. And specifically, the last count at issue, gross negligence, included an allegation specifically under that count that in addition to the obligations imposed by the terms of the agreement between Archer Western and Zion, that Archer Western owed a heightened duty of care to Zion pursuant to that agreement. And so ultimately, in evaluating whether an arbitrable issue exists, any doubts as to whether the claim falls within the scope of the agreement should be resolved in favor of arbitration. And if there is no further questions, I'll reserve the rest of my time for rebuttal.
All right. Thank you.
Good morning. May it please the court. My name is Niels Murphy from Jacksonville. Andrew Brigham is my co-counsel. Together, we have the pleasure of representing Zion Jacksonville LLC, or Zion Jacksonville Inc. The two questions here that were presented are as follows. One, does the Seifert significant relationship and contractual nexus test even apply to the broad language of the contract clause, the arbitration clause at issue? And number two, if yes, is there a significant relationship or a contractual nexus between the contract to sell A3 sand and Archer Western's surreptitious dumping and burying of litter and unsuitables on the Zion property?
Let me ask you about that, if I may, Mr. Murphy, and you heard my questions. We know we have a pleading here, and incorporated by reference into each count, every count, is the agreement. And so embedded on every count that we're here about today, we have this agreement. We also know, based on the rules of procedure, that any exhibit attached to a pleading must be considered a part of the pleading, and here a part of that claim. How does that not create a significant relationship for these four claims?
Well, first of all, in the Seifert decision, the Florida Supreme Court specifically found that having a contract in and of itself does not create a significant relationship. You have to look at the contract itself and then determine, based on the conduct at issue, the claims at issue, whether or not there is a significant relationship.
And thank you, and that's a good point, Mr. Murphy. But in Seifert, as I understand it, and perhaps you can correct me if I'm wrong, the plaintiff made no attempt to reference the agreement, just the opposite. I mean, there was no mention of the agreement in the claim. And here we have, contrary to that, in every claim your client is making, we have the contract. So doesn't that set this distinctly apart from Seifert?
I don't think so, Your Honor. And let's back up for what the procedure was. We included in our original pleading a breach of contract, a breach of unjust enrichment, and these tort claims. Judge Anderson made the decision after Archer Western moved to compel arbitration to remove those contract claims from the pleading. They're not there anymore. So the pleading isn't the same before this court as it was originally. Those contract claims are no longer part of the record.
And I understand that, but the claims that are still being advanced, the tort claims,
Yes.
still incorporate by reference this agreement, correct?
They do, but they're not, I mean, they don't need to be reviewed because you just need to look at the nexus between the contract language and whether or not there's a significant relationship to the claims, to those causes of action. And those causes of action here are violation of Florida's litter law. There is no need, as Judge Anderson found specifically, those are independent duties. They don't rely or require any reference to the contract.
Counsel, how can you tell us that we don't need to look at the agreement? One of your claims is they took more dirt than they should have. Well, unless you know how much they should have, you don't know that they did. And likewise, the trespass claim too, which is similar. And in fact, the claim that they basically stole fill dirt by bringing back in this crummy retention pond stuff so that they could hide how deeply they excavated. Without knowing what they should have been doing under the agreement, how can you evaluate whether they committed a tort or not?
So that That's a great question. The removal of dirt is the breach of contract claim. The contract between my client and Archer Western was they're the buyer of A3 sand. We're the seller of A3 sand. The breach of contract solely relates to they took more sand. That's not part of the lawsuit anymore.
Part of tell me what the trespass is then. Part of the trespass, as I read the complaint, is they took more dirt than they should have.
No, the trespass is they came onto our property and dumped trash and litter and unsuitable material all over.
Part of which was to hide how much dirt they took, wasn't it? I mean, that's a claim, isn't it?
That's not part of our claim for the trespass. Our only claims for the trespass.
Is it part of the claim for fraud?
No, the fraud would be coming onto our property and concerting with these trucking companies and dumping all the litter and unsuitables, which ultimately devalued the property. That's really our claim here, is the economic loss that was suffered by my client on one of the most pristine parcels of land in Northeast Florida, where they surreptitiously came on the property and not only did they dig huge holes, they filled them with trash and all sorts of unsuitable material.
I get that, and I understand how that could be a good claim, but unless you know what they were supposed to be doing, I thought there was a claim in the complaint that they dug too deep. It was supposed to be an elevation plus 10. They dug deeper than that. They were hitting the water table, all these kind of things, as part of the claim separate from just simply breach of contract.
No, those are limited to the breach of contract claims. Those claims are no longer part of the complaint, along with unjust enrichment, which would be the compensation that we're owed for them taking too much material. The tort claims are absolutely independent, and you do not need to look at the agreement in order to determine whether or not there was a substantial relationship or a contractual nexus.
And I certainly hear you, but I also hear Judge Edwards and his good point. But if they were not needed, why were they incorporated by reference? Why was the agreement made a part of these claims if it was not needful? I mean, it is there now. I mean, we can't redact it out.
Well, I think they have been redacted out by Judge Anderson's ruling that the contract claims are gone. So all of those contract claims, whether they're by reference or whether they're in their preliminary statement, are not part of those claims. What he did is he said, okay, these tort claims are going to remain, and those tort claims are all independent. You don't need to look at the contract to determine that.
And that all may be true, but that proverbial ship has sailed, Mr. Murphy, in this judge's humble opinion, because the contract is a part of those claims. And as I pointed out with Ms. Corey, paragraphs 127, 128, 129, 130, 134, and 135, all incorporated into these tort counts, talk about the agreement and how the activities here were outside the agreement. So back to Judge Edwards' question, based on those paragraphs that are a clear part of the tort claims, how do we possibly evaluate the propriety of the tort claim without understanding what the contract allows?
Because you don't need to look at the contract to evaluate those tort claims. All you need to do is look at the photographs. The photographs here show that there is no significant relationship between the contract itself and the conduct at issue.
What do we do with these words, though? Do you have the contract or the complaint? I'm sorry.
Yeah.
And just take your time, Mr. Murphy. But I'm looking at paragraph 127, 128, 129, 130, 134, 135, and for example, 127 talks about Archer Western not being authorized to enter for any purpose other than what was explicitly spelled out. So in order to evaluate trespass, as Judge Edwards pointed out, wouldn't we have to evaluate the purchase order contract based on this plea?
Well, with all due respect, you wouldn't need to look at the contract because the contract absolutely does not mention anything about coming in and burying all these different types of things like road waste, asphalt, concrete. In fact, the contract is limited to the purchase of sand. That's it. So you can't even come in defense. Archer Western can't come in and say, oh, well, look at the contract. It says we have the right to be there. Well, nowhere in the contract does it say that you have the right to be there to dump sludge, concrete, asphalt, rebar, wood, tires, metal strapping, pump thousands of gallons of water into
Why were they there? I mean, the contractual nexus, this is not they ran into something unconnected with one of their dump trucks and, ran over something at your other place of business. This is all about how did they go about excavating the sand for this project, and what did they do in connection with their presence there that was wrongful?
Well, with all due respect, they're very different. And the analogy I used with Judge Anderson at the hearing was, if I have a contract with a pool company to come and clean my pool, right? They come, they clean the pool, they change the chemicals. But do they have the right to go in my backyard and dig a hole and bury all the chemicals and waste from their other projects and then cover it up? Is that contemplated by the contract? Absolutely not. But they did have a contract which allowed them to come on the property and to clean my pool. And so that's what Seifert's all about. It says we have to look at this significant relationship and contractual nexus between the claims and the contract. And this,
If we were defined, I'm not saying we will, but if we were to find that you have pleaded a nexus, I just don't know how we get around that. And it looks to me that a nexus has been pleaded in this complaint.
in my position, Your Honor, would be that Judge Anderson's already ruled that those contract claims now are going to arbitration. They don't remain. And so therefore the remaining claims are these intentional tort claims, which are independent from the contract. We don't need that introductory language. In fact, the introductory language really doesn't apply anymore.
So why reincorporate those 6 paragraphs I just referenced into the tort claims?
I think it's probably just standard practice, Your Honor, or maybe that's on us for incorporating those. But part of the reason is because when we made the decision to file the claim, we don't know whether Archer Western wants to be in court or arbitration. It happens all the time that you file all your claims in court.
Why does that matter? I mean, you're the one who initiates the lawsuit, and you're the one that makes the call to say, okay, we have these 6 claims, 2 are contract related, we'll attach the copy of the contract, et cetera, to the complaint and incorporate those into those 2 counts. But these other 4 counts that you reference as all tort counts, yes, there's a document attached to the complaint, the contract, but we don't incorporate those into these counts because those are, as you apparently successfully argued below, those are independent of the contract. I think what Judge Jay is, you keep saying, well, those are away. The contract claims may be away. The contract you incorporated into these counts that has an arbitration provision. And if we have to broadly construe arbitration provisions, why, I think Judge Jay is trying to tell you, which makes a lot of sense to me, is that you guys are the ones who incorporated the arbitration provision into these counts, and now you're trying to back away from it. And why should we let you do that, or why should we support the trial court's ruling allowing you to do that?
Well,
that seems to be what our issue is today.
I understand. And maybe this would better address it, Judge Jay, is that if you look at, for instance, the organized fraud count in the complaint or the gross negligence count, there's no, other than the reincorporation, there is no reference in those allegations for those claims to the contract itself. If you look at the well-pled allegations of fraud and gross negligence, they are absolutely independent of the contract as they appear in the complaint after that general reference paragraph.
And if the contract had not been incorporated by reference, and these 6 paragraphs I just read to you or referenced were not incorporated by reference, that may be a compelling argument. But in front of us today, looking at this complaint and this agreement, we're duty-bound, are we not, to follow what was pleaded?
Well, I disagree that you're duty-bound on that issue. I think you can look at these independent claims as they are alleged in the remainder of those counts, given that Judge Anderson has already dismissed the contractual claims and forced those to arbitration. I guess what you're suggesting is that we should amend our complaint now that he has dismissed those, ask for amendment, and just delete those, and then we'll be right back here on the same issue.
Yeah, I can't advise you, Mr. Murphy. I just know what's in front of this court. I know what we're tasked with evaluating, And I just don't see a way for you to credibly argue that the agreement is not a part of these claims when it overtly is, including the allegations that the agreement matters to these claims.
Let me follow up this, and let me follow up the trail you're going with a hypothetical. And let me say this, which I've historically said. If it's a hypothetical, that means I'm making it up. So your response shouldn't be, well, that's not the facts. I mean, that's why it's a hypothetical. Let's say you never asserted the breach of contract or the unjust enrichment causes of action. You just asserted the 4 tort claims, we'll call them generically. But you attached the contract that explained the relationship between the parties and why they're there, why the Walsh Group is there. Why wouldn't we look at, and it's a de novo review, isn't it?
Yes.
It's de novo review now. So why wouldn't we sit there and look as the appellate panel as to what the trial judge ruled as a matter of law, decide whether that was right or wrong, because we're looking at the nexus that's created by the pleadings to the contract that has the broad arbitration provision. I mean, you keep going down the rabbit hole of, well, those contract claims are gone. Okay, let's forget they were ever there.
Right.
There's still a contract. There's a contract versus contract claims. There's a contract that you guys have alleged that is part and parcel of all this.
Well, Your Honor, my response to that would be is Archer Western hasn't even answered the complaint, but presumably they're going to answer the complaint. They're going to attach a copy of the agreement, right, as one of their defenses. Does that mean that part of the pleadings, that the contract's part of their affirmative defense and therefore it should be considered? I would say no. You have to look at the causes of action themselves. These causes of action are independent of the contract. It doesn't matter whether we bring them up in trial as evidence, whether they bring them up as a defense, whether the jury hears about them. The issue is, what are the causes of action? And the 4 causes of action here are violation of Florida's litter law, which is absolutely independent of the contract.
Well, it could be. It could be. It could have been. But again, I'm looking at, for example, 132, you talk about they used the purchase order and their authorization to be there as a front or cover so they could go do this dumping. How do we go forget about the contract? You're the one who keeps talking about the contract, the agreement. It's not us, it's not the defendant, it's you guys said, look at this contract, here's all they should have been doing, but here's what they were doing instead. How do you not compare the conduct?
So how I respond to that is like the whole lineage of cases that say just because there's a contract, just because there may be discussion about the contract doesn't mean that there's a nexus or a significant relationship between the claims and the contract. And that's what we're alleging here. They're totally independent. These 4 causes of action do not, in our position is, organized fraud and gross negligence and the litter law don't have to do with the purchase of sand. They went out on the property and dug holes, dumped trash in those holes, and covered them up. That doesn't have anything to, there is not a significant relationship or a contractual nexus between that conduct and a contract to buy sand.
Well, they used it as a front or cover, you said. The contract that they used to pull off exactly what you said they shouldn't have been allowed to. That's your pleading. That's what you say, not us.
But again, those claims, the causes of action still stand on their own, regardless of that. And so I think the court is supposed to look at the individual causes of action. And that's what Judge Anderson did. He said, can these claims stand on their own? These 4 causes of action, are they independent of the contract?
Where is there a test that it's just simply standalone versus a nexus? We're not saying they could or could not stand alone. The test is there a nexus between the contract or agreement here, the purchase order, and the tort you're alleging? And you go out of your way, as Judge Jay has pointed out in detail, to say, here's why they're there and they're using this as a cover. Here's what they were supposed to do. Instead, they did this. They were only supposed to take sand away. Instead, they brought this crud from the retention ponds. I mean, you keep making the comparison. They're only supposed to do this, but they did that. That's the nexus we're talking about. They may have been able to stand on their own, but that's not how you pled it.
And of course they could stand on alone. I mean, if Walsh had never heard of you guys before and said, using your term, there's this pristine land, we're going to go trespass on their property, even though we never heard them before yesterday, we're going to go trespass on their property and litter all over it, then yeah, you would have a standalone claim. about that, but you don't. And again, it kind of is getting down to you don't like what you all put in your pleadings, and you're kind of wanting to walk away from that, saying, well, these are standalone because Judge Anderson said so. Well, with all due respect to Judge Anderson, he didn't make a final call, did he?
No, it is a de novo review, and of course it's up to you, but our position is not just Judge Anderson's position, it's the position we argued to Judge Anderson, and that the contract in and of itself has nothing to do with the conduct at issue ultimately in these claims, and those contract claims have been removed, and going forward in the lawsuit, we should have an opportunity to make those arguments to a jury. And then just to address real quickly, because I have a few seconds, I do want to address the Archer Western's argument that there should be some wild card language, as Judge Anderson put it, and that their language is so broad that Seifert doesn't even apply. And there is no such thing as wild card language, and the Seifert opinion is super clear. In fact, the court was specifically found that even in contracts containing broad arbitration provisions, the determination of whether a particular claim must be submitted to arbitration necessarily depends on the nexus. And so Seifert clearly found broad means broad. They can't have this wild card super broad where, oh, we don't have to follow the Supreme Court precedent.
All right, thank you.
Thank you.
Thank you.
May it please the court, 2 points for rebuttal. First,
Can I ask you, what's this wild card thing that your opponent's talking about?
it's in
Using his words, I'm not sure what that means, but go ahead.
I think it's in reference to a U.S. Supreme Court case discussing arbitration provisions and the scope of them. And so in relation to the plain language argument, it's my understanding that their position of Zion would be that the provision is too broad. And
You don't think you're playing the wild card here, do you?
no, we don't. These are sophisticated parties that negotiated this contract with several teams of lawyers that have, agreed to these terms, and so it would not be our position. First, there is no revised complaint here. The fact that 2 claims have been compelled to arbitration does not negate the allegations that this court has referenced and that are at Appendix 12 to 17 and 36 to 39 of the complaint that are not only incorporated into each count individually, but each count at issue does include allegations that will require reference to the contract at issue.
What would have happened if the other side got your motion to compel and they say, oh my goodness, I know someday I'm going to be in front of those 3 judges talking about our pleading. I'm going to move to amend the pleading to delete any reference in those 4 counts to this contract, and therefore, yeah, you can sever the contract claims that the contract relates to, but not these, I'll generically refer them to tort or statutory claims. How would that have played out in your mind as it applies to your argument here?
Right, and obviously the attaching and the referencing to the purchase order agreement is a good indicator of the contractual nexus, but the contractual nexus exists between a claim and a contract when the circumstances that are presented by the allegations need a resolution of the disputed issue requiring reference to construction of a portion of the contract. And so even if the contract had not been attached, these allegations as pled in the 4 counts are going to require that reference to and construction to the contract. In order to determine what conduct is authorized, unauthorized, we must determine the scope of the purchase order and Archer Western's conduct in order to be able to adjudicate these claims by a fact finder.
Well, their argument is, all we did was agree to sell you guys some sand. How does that then translate to you guys now? It's Katie bar the door, you come through the gates and dump all your tires and sludge and other bad things that have affected their property.
And if we look at Appendix 98 of the purchase order itself, Archer Western was required by the agreement to visit the Zion property during this excavation process, and that included preparation of the area afterwards, a regrading, and it also included in the interim construction of haul roads. So obviously there was going to be material coming in, material coming out, and so In order to resolve these claims, we're going to have to define what that conduct looks like and evaluate the quantity and material removed from the Zion property and what mutual agreements were made between the parties as it relates to execution of that purchase order agreement. And so for these reasons, we would ask this court to reverse and remand for an order compelling all claims to arbitration. Thank you.
All right, thank you. We will be in recess.
Thank you both.
All rise.